69% of Americans have no will at all. Not no trust, not no estate plan, no will, nothing. Stay with me because in the next 10 minutes, I am going to show you the real difference between a will and a trust, who actually needs each one, and exactly what to do this week to protect your family, no matter your budget. Let's go. A will is a legal document that explains what you want to happen to your assets after you die. It lets you name your beneficiaries. Who gets what? It lets you appoint an executor, the person responsible for carrying out your wishes. And critically, it lets you name a guardian for minor children or dependents. A trust cannot do that last part. For families with young children or adults with special needs, a will is essential for that reason alone. Wills are relatively simple to create. A basic will can cost as little as a few $100s with a local attorney, or significantly less with online services. They are easy to update when circumstances change. A new marriage, a divorce, a new grandchild. But here is what a will cannot do. A will does not take effect until you die. If you become incapacitated, a stroke, dementia, a serious accident, your will is legally useless while you are still alive. You would need a separate document like a power of attorney to handle your affairs while living, and when you do die, a will does not automatically transfer your assets to your heirs. It sends them to probate court first. A trust is a legal arrangement where you transfer ownership of your assets to a trust entity, which is then managed by a trustee for the benefit of your beneficiaries. Here is what makes a trust fundamentally different from a will. A trust takes effect the moment you sign it and fund it, not at death, right now. That means a trust can manage your assets during your lifetime if you become unable to manage them yourself. Your successor trustee steps in immediately, without involving a court, without delays, without public record, and when you die, assets held in a properly funded trust skip probate entirely. Your beneficiaries receive what you intended faster, more privately, and often at significantly less cost. The most common type for retirees is the revocable living trust. You maintain full control of the assets during your lifetime. You can change the trust, add assets, or dissolve it entirely if circumstances change. Only at your death does the trust become irrevocable. There is also the irrevocable trust, which is more complex, involves giving up control, and is typically used for specific tax planning or asset protection purposes. Most retirees do not need an irrevocable trust, but it is worth knowing the distinction. Probate is the court process that validates your will, settles your debts, and oversees distribution of your estate. It sounds orderly. In practice, it is often expensive, slow, and public. Expensive because probate costs typically run between 3 and 8% of your estate's total value. On a $500,000 estate, that is $15,000 to $40,000 paid to attorneys, court fees, and administrators, money that would otherwise go to your family. Slow, because the probate process can take anywhere from 6 months to 2 years or more, depending on your state and the complexity of your estate. During that time, your beneficiaries generally cannot access the assets. They wait, public, because once your will is filed with the probate court, it becomes a public document. Anyone can look it up. Your neighbors, salespeople, scammers. They can see what you owned, who inherited it, and where those people live. A properly funded living trust avoids all of this. No probate court, no public record, no mandatory waiting period. Your successor trustee can begin administering the trust often within weeks, not years. Here are the 5 situations where a trust makes the most sense. Situation 1, you own real estate. Real estate must go through probate unless it is held in a trust or has a specific beneficiary designation. If you own a home, a rental property, or land, Placing it in a living trust is often the most straightforward way to pass it to your heirs without court involvement. Situation 2, you own property in multiple states. If you have a vacation home in Florida and a primary residence in California, your estate could face probate in both states. This is called ancillary probate, and it doubles the cost and complexity. A trust solves this entirely. Situation 3, you want privacy. If you do not want your financial affairs to become public record, and you do not want your beneficiaries to be exposed to unwanted attention after you pass, a trust provides that protection that a will simply cannot. Situation 4, you have a blended family or complex beneficiary situation. If you have children from a previous marriage, a spouse who needs income during their lifetime but should not control the principal, or a beneficiary with special needs who cannot receive assets outright without affecting their government benefits, a trust gives you the control to handle all of these situations precisely. Situation 5, you want to plan for incapacity, not just death. A will is useless if you are alive, but incapacitated. A living trust already has your successor trustee named and ready to step in immediately with no court involvement. This is increasingly important as people live longer and the risk of a period of incapacity before death is real. A will may be sufficient if your estate is relatively simple. If you have modest assets, straightforward beneficiary designations on your accounts and retirement plans, no real estate that needs to pass through your estate, and no complex family dynamics. A well-drafted will may cover everything you need. Most financial accounts, retirement plans, and life insurance policies allow you to name beneficiaries directly. Those assets pass outside of probate entirely, regardless of what your will says. If the bulk of your estate is in these types of accounts with current beneficiary designations, your probate exposure is already limited. Even in these cases, most estate planning attorneys recommend a will as a minimum. It covers assets that fall through the cracks. It names your executor. And for anyone with dependents, it names their guardian. Many people use both a will and a trust together, and this is often the recommended approach. The strategy is called a pour-over will. You create a revocable living trust and fund it with your major assets. You also create a will that says, anything I own at death that is not already in my trust, pour it into the trust. This ensures that any assets you forgot to title in the trust name or acquired late in life still end up in your trust and are distributed according to its terms. The pour-over will does go through probate for those remaining assets, but the trust itself remains private and efficient. You do not need to spend thousands of dollars to get started. Option 1, a basic will online. Services like Trust and Will, LegalZoom, and similar platforms offer basic wills starting around $100 to $200. These are appropriate for simple situations and are a significant improvement over having nothing. Option 2, an online living trust. The same platforms offer revocable living trust packages, typically starting around $300 to $500. These include the trust document, a pour-over will, and basic guidance on funding the trust. Option 3, an estate planning attorney. For more complex situations, a blended family, significant real estate, business interests, or an estate that may be subject to estate taxes. Working with an experienced estate planning attorney is worth the investment. Fees typically range from $1,500 to $5,000 or more, depending on complexity and location. Whatever option you choose, do something. The cost of having nothing is far higher than the cost of any of these options. Talk to your family about what you are doing and where the documents will be kept. An estate plan that no one can find is an estate plan that does not work. A will or a trust is not just paperwork. It is a decision about whether your family goes through a court process at the worst possible time in their lives or whether you gave them a clear path forward. 69% of Americans have not made that decision yet. You now know more than most people ever will about this topic. If this video helped you, please share it with someone who needs to hear it. And subscribe if you haven't already. Stay safe and stay protected.